This bill, SB 1418, is pretty desperately needed in our society. Now, half the challenge of the bill is convincing conservatives that it's the most conservative bill since sliced bread, and convincing progressives that it's the most progressive bill since sliced bread. And it is. We've all seen the terrible politicization and weaponization of our justice system. And we could sit down over a beer and tell stories from the perspective of the left and the perspective of the right. It's the way that we've seen it in our own activism, in our own work. But those stories shouldn't exist at all. Prosecutors should make their decisions to prosecute based solely on a desire to deter and prevent crime from happening. That's what we expect of our prosecutors. And back when we had more rational and less cluttered criminal and administrative laws, we didn't have to rely too much on the integrity of those with power in our system, because the things that were illegal were things that everybody agreed were wrong. But over the past several decades, we have constantly cluttered our criminal justice system with an increasing amount of vaguely worded crimes. I see it in Judiciary Committee every week. 7 new crimes every week for decades. We've gotten to the point where everything is illegal. And when everything is illegal, everyone is a criminal. And the only thing stopping the state from coming after you is the discretion of the prosecutor. The question is, should that discretion be exercised with a political motivation? I would say the answer to that question is no. Now, I mentioned that this bill is part of an unlikely coalition of left and right, something that we're building upon to really fix and reform our justice system in a deep and systemic way. And the supporters reflect this. I don't think you'll ever see Abe Hamadeh, Congressman Gosar's general counsel, Tom Van Fleen, the Republican Liberty Caucus, the American Conservative Union, CPAC, the Arizona Association of Criminal Justice, the ACLU, and the Public Defenders Association ever pulling together in the same direction this session. But you see it here. And people ask, well, how does this change the law from what it already is? Well, last year, this body passed a fairly substantial expansion of the anti-SLAPP law. It means strategic losses against public participation, essentially a law that protects you if you get sued for First Amendment protected activity. For the first time, it included state actors, the government, to the plaintiffs to whom this could apply, and subsequently to the defendants who would be able to assert the defense, right? When the government comes against you, you can do it. But the bill had a deficiency. The bill's deficiency was that it limited anti-SLAPP motions to areas where the exercise of First Amendment protected activity was lawful. But as I've just explained, and as our speakers today I'm sure will explain further, everything is already illegal. If you stand around at a protest about our elections or a protest about Black Lives Matter, and somebody breaks a window or burns down a building, you're an accomplice, even if you're just standing there. We have laws that make it a federal offense to slice canned peaches incorrectly, a federal crime. You commit crimes every day that you don't even know. So to limit the bill to just lawful expressions of First Amendment activity, well, that's meaningless because a prosecutor can always find the crime if you show him the man. The bill has another component that's a change from last year, a private right of action. Now, this does 2 things. First, the private right of action that can be brought after the underlying proceeding means that there is an avenue for post-conviction relief. I've been, of course, talking to Hope Delap that since I was thinking in the administrative context and the civil context, that this is not necessarily structured in the optimal way for the criminal context, because I was thinking civilly and administratively. But it does. It does provide an avenue to have a conviction set aside if you've been prosecuted because of your political or religious beliefs. And I know it's something that we need to work on to make it even better. The other thing that I would say is it makes it even more clear that this also applies to regulatory boards, because state actors coming after you civilly or criminally is not the only thing we're concerned about. We've seen in many circumstances people with politically unpopular views, for example, medical professionals, being come after by regulatory boards because of their expression of those views. We don't want that to happen in our society. Whether you agree or disagree, you should be free to speak. And finally, It removes the immunity for those who would prosecute people with a substantial motivation to deter or dissuade others from holding certain political or religious beliefs. Because why should the taxpayer have to pay for a prosecutor who decides to abuse the public trust to go after his political opponents, for a board, for a regulatory agency, for somebody in a position of power who can bring a civil suit on behalf of the state of Arizona or political subdivision? Why should the public have to pay for that? The point of the private right of action is so that the bill never has to be used. Because people who are in bureaucracies, they don't like to rock the boat. They don't like to take personal risk or whatever. And so what this bill tells them is it's personally risky if you are going to abuse your office in this terrible way. And therefore, our hope is that they will spend their time prosecuting things that are real crimes with the simple motivation to protect the public. Just as Peel's principles of policing, the foundation of the Arizona criminal justice system, provides. Now, I want to talk about what this bill does not do. This bill does not create a right of action against police officers. Immunity is preserved for police officers, for the arresting officer here in the bill, right? This is a bill that talks about those who have the discretion to bring charges, to have the discretion to bring administrative actions, to have the discretion to bring civil actions. It's not going after people who are told what to do and then go and do it. So that's the bill. I'm going to turn it over to our speakers now. They're going to present very powerful testimony. This is the most substantial start towards criminal justice reform that we have encountered in decades. This is our shot. Because I told Nate at the beginning of the year when he called me up, we have a mutual friend, believe it or not, who I don't agree with on any other issue. And he said, I want you to meet my friend Nate Wade. And Nate calls me up and he says, you know, we get to talk, we hit it right off. And he goes, I don't know if this is going to be a productive year for criminal justice reform. I go, Nate, there's a new crop of people coming into this legislature from both the left and the right. And they're more radical than they've ever been on either side. But that brings them to want to move this issue forward. And I think this is going to be a much more productive year than any of you can possibly imagine. Prove me right, guys. Prove me right.
Pat Nolan.
I'm Pat Nolan. I live in Prescott, and I represent the American Conservative Union and CPAC. I founded the ACU Center for Justice in 2014. They've kindly named it after me. I'm an Arizonan by choice and by the grace of God, but I'm a fifth-generation Californian by birth. And from 1978 to 1994, I was a member of the State Assembly in California, and I served 4 of those years as Republican leader. We were in the minority the whole time. I'm a living example of someone cut down by political prosecution, and it should stand a lesson to all of us of the dangers of public service. By 1988, I'd led the Republicans to within just 5 votes of a majority, and all of the pundits predicted that we would become a majority the following election in November. Those efforts came to a crashing halt on the night of August 27, 1988, when my office was raided, purportedly in search of evidence of bribery. It was just 10 weeks before the November election. They claimed I'd been bribed to support a bill. I did support the bill, and I did receive a contribution. But the contribution came months after my last vote for the bill. The legislation had passed both houses overwhelmingly, 76 out of 80 in the Assembly, and 37 out of 40 in the state Senate. But essentially, they accused me of retroactive bribery. But the jury pool in Sacramento was very anti-legislator. There'd been some convictions of other legislators. And when we did a poll of prospective jurors, we found that 67%, without hearing any evidence, 67% said that I was guilty. The judge refused our motion for a change of venue. So I was stuck being tried in front of a jury that before they heard anything, 2/3 of them thought I was guilty. I was convicted and served 29 months in federal custody. My children were 5, 4, and 10 months at the time when I went into prison, and I lost those precious years of their childhood. I was broke, disbarred, and my reputation destroyed. However, God had better plans for me, and I'm able to appear before you today having received a full presidential pardon. What was done to me was wrong and should never be allowed to happen to anyone that's a legislator again. You and I are all people of modest means. How on earth can we stand up against the full might of the government? Representative Kolodin said that there are so many laws, they can convict anybody of something. In investigating, one of my colleagues, a state senator, an IRS agent said, "Senator, we can carve our paddle to fit anybody's ass." Pardon me, but that's a direct quote. And that's their attitude. Of course, that reflects what Beria, head of Stalin's secret police, had said. You bring me the man, I'll find the crime. And any one of us is vulnerable to that. And it's not just me as a Republican. It's happened to Democrats. Bill Honig was California's superintendent of public instruction. He and I fought over education issues. We debated publicly many times, but he was an honorable man. And yet a Republican attorney general took him out by claiming that he diverted funds from the office of superintendent to his wife's foundation, which they were under contract with to provide services to schools. It was hokum to claim that he was guilty of anything, but he was convicted because of the same reason. The public distrusts all of us that hold office. And this fine man had his career destroyed. His wife committed suicide. And he paid a heavy price for having tried to serve the public. For 20 years, I lived in Virginia working as head of Justice Fellowship with Chuck Colson. Virginia's Governor Bob McDonald was accused of helping a donor get a state contract. His conviction was overturned unanimously by the Supreme Court. But in the meantime, he'd lost his office, he'd lost his wife, and he was broke. The parties certainly have our differences, but it's wrong that politics have become a blood sport. Think what would happen to you if you were taken before a jury here in Maricopa County.
Good morning, Mr. Chair, representatives. My name is Nathan Wade. I am a criminal defense attorney, and I'm the legislative co-chair of Arizona Attorneys for Criminal Justice. AACJ is a nonpartisan organization of both public and private defense attorneys. I stress nonpartisan. Our mission is to protect the rights of the accused and to ensure that the Constitution is followed when it comes to criminal justice. As such, our role at the legislature is to safeguard those rights and to make sure that in the arena of criminal justice, all voices are heard before our criminal justice system is expanded and to protect from government and special interest overreach. I can tell you when we have discussions about what bills to support, what bills to oppose, we have often quite robust discussions. And when we make our decision, we come back to that last statement. We are working to prevent the criminal justice system from being exploited and expanded and to protect from government overreach. This bill is nonpartisan. It does not target one set of beliefs or another, nor does it prevent a neutral prosecution of crimes solely based on the facts of a case and consistent charging. So I do want to stress that what this does is deter any prosecution that is based on anything but the facts of the case. It deters prosecutors from using their own disagreement with a group's political or religious beliefs from prosecuting them or allowing that to color their decisions. How do we know that this happens? I'm going to use an example of cases that members of our organization, AACJ, worked on. A few years ago, during a political protest, under the previous regime at the Maricopa County Attorney's Office, a choice was made to twist facts and fabricate information in order to charge the protesters with enhanced felonies based on their political disagreement with the subject of the protests. Several of our attorneys represented these protesters pro bono, not because of the nature of their belief or the nature of the protest, but the fact that they were being targeted for the nature of their belief and their protest. Our attorneys would do that in any situation, no matter who the person being targeted was. Thanks to the diligent work by our attorneys, with an assist by the media, documents came to light showing that there were behind-the-scenes plans to enhance those charges and that those enhancements were politically motivated. That should chill anyone on either side of the aisle to worry that someone who disagrees with you uses their disagreement to prosecute or enhance that prosecution. Bills like this will deter these types of prosecution. Persons, no matter their political beliefs, should never have to worry about expressing them.
I thank you for your testimony. You've talked a lot about the deterrent effect of this in your field, which is criminal justice, and how this could prevent some of the problems that we've seen in the past on both sides of the aisle. I wonder if your work has brought you into contact with administrative proceedings to which this bill also applies, and whether you could speak to whether the beneficial effects might extend there.
Personally, I have not had that crossover, and I've never had personal issues with that. I do think, again, it is ripe for abuse. I do think that one thing that is good in this bill, whether it's an administrative agency or a prosecutorial agency, is that the burden is on the defendant, to prove that it's happening. So like, you can't just say, oh, you're doing this because of my political beliefs. So there are built-in protections for prosecutors. We can't just go and say, you did this because you don't like me. You have to be able to prove your claim.
At that point, so you're accused of something and you have to prove that you didn't do that. And then if I'm the one that accused you, do I have to prove that you did do that?
If I, for example, am at a protest on any issue and I have a question about why I'm being prosecuted, or, in a case where something that would normally be a misdemeanor is suddenly being charged as a felony, I think that would give anybody pause as to why that's happening when it's not happening consistently. I think in these cases, the attorneys for the accused do their due diligence. They do the FOIA requests. They do the discovery requests. They don't raise the issue until they feel like they have a valid claim. It would be irresponsible of a defense attorney to just throw that out there. But we have seen it happen. Again, as Mr. Nolan has so eloquently stated, it's happened to both liberals and conservatives in these situations. I think there would be sanctions if a defense attorney just raised it with no background on it, with no research, with no proof. That's kind of what an affirmative defense does. So the prosecutor has to prove their case with evidence. If I'm going to raise an affirmative defense, I better be able to back it up before I raise it.
I did have a quick question. You mentioned the previous administration of the Maricopa County attorneys, and they found that it was because of the political stances and who the people were. During that time, I just want to verify the protests you were referring to, were those the protests that were during the Black Lives Matter movement, stuff that was happening?
Mr. Chair, Representative Hernandez, yes, that was the protest, and several of our attorneys worked on those cases. And again, those claims were not made until there was evidence of that.
You had just talked about what you saw during the Black Lives Matter protest. I wonder if you were aware of the criminal referrals that have been very publicly sent to the Attorney General's office regarding some statements that Carrie Lake posted on Twitter and asking for an investigation into those as crimes. Does that give you echoes of the Black Lives Matter defense that your team did, and does that give you a similar concern?
I think it would be, again, just like those protests, I think that any diligent defense attorney would do the same due diligence and do the same discovery process to determine that, and if that was the case, then yes, you would raise the issue.
Could you give, I guess, your opinion of what might be considered evidence to a politically motivated prosecution?
There were emails back and forth. There was evidence of coordination between someone in the county attorney's office with someone in the police. There was a decision to create a fake gang, basically, that did not exist. So it was pretty clear. I think that if it were the same situation in a MAGA protest and said that MAGA is a gang now, for that we would have the same issue if those things happen. So again, while I'm using an example that is more left leaning, I think that the same standard applies no matter who the speech would be.
Representative Bravo?
No.
Representative Gutierrez?
I walked in today thinking that we were having a special meeting for the Reg Affairs Committee, and I've just sat through a hearing where prosecutors are bringing cases against people because of their political ideology. We were given less than 48 hours to read and digest this language that should have gone through the Judiciary Committee. I'm concerned that the public, who we are here to serve, didn't get adequate time to catch that this bill was being heard today. I would have loved to hear from those opposing, since there are many, many opposed. I can only go by what my city has told me, that they have very big issues with this. And to be honest, I found it jarring that, I know, Mr. Kolodin, you have been working on this, but that you're sitting in today. I don't feel comfortable voting for this, so I'm a no.
Representative Hernandez.
I understand that there are some amendments that are being worked out right now. I have had multiple conversations now, including those with the criminal justice reform attorneys and with also Representative Kolodin, who has expressed that those amendments are coming to the floor. So I will be voting to support this bill right now in committee, with the understanding that those amendments will be getting on the floor. If that does not happen, then I will be changing my vote, but I will be voting yes right now.
Representative Payne.
Aye.
Representative Cullivan.
You know, it's funny because we've heard stories about this happening sort of on both sides of the aisle. And my back was kind of going up when I would hear the Democrat examples and go, you know, okay, a Republican's going to be able to live with the fact that this protects, you know, Democrats. And then my back would go up when I'd hear the Republican examples, or will Democrats be able to live with the fact that this protects Kerry Lake? And I think the answer is, at least a lot of us can. That we still believe that the First Amendment and that political speech and expression is to be valued for its own sake, and not just necessarily because we agree with the speaker. And I'm humbled today by that support, by the coalition that we've gathered to seriously take on criminal justice reform. I think when this bill passes, it's going to be the first blow, first victory in a very new battle to overhaul our system of justice and make it fair for all Americans. Because when people are targeted on their political beliefs, when prominent people are targeted on their political beliefs, right, it scares normal people. I can't tell you how many times in the past couple of years I've had precinct committeemen come up to me and say, am I safe if I put this on Twitter? Am I safe if I say this? And I'd always say back to them, I can't believe we're even having this conversation in the United States of America. And it is sad. It's sad that you need to have a bill like this. We shouldn't need to have a bill like this. It's wrong that we need to have a bill like this. But we do. We do need a bill like this. And so for those reasons, I vote aye.
Vice Chairman McGarr.
With Representative Culloden, I do sit on the Judiciary Committee, and I want to echo his points that there is always a tremendous amount of pressure to over-criminalize specific activity, to create new felonies, new ways of, in many cases, duplicating the effects, but expanding it. And there's always a scenario in which there's unintended consequences to the laws and the felonies that we create. It is very easy to accidentally commit a crime nowadays. And we don't have to look at the political environment very long to see that there are politically motivated, I would have a Freudian slip and call it a persecution. We see this all the time. Individuals should not be in the position to fear using their free speech or practicing their faith, or even sitting here, we vote our conscience, which we have the right to do. And imagine you make an enemy because of your vote, and someone else in power who doesn't like it pursues you and tries to get you in some sort of technicality and convicts you. That's not something that we should be allowing. I think we should get back to the point where, and this is kind of more of an older adage, that I may not agree with what you say or what you believe, but I will fight for your right to do that. So this is the beginning step to stopping that kind of behavior from people who would use this to silence critics or just strip your rights. And so with that, I vote aye.
I vote aye. Members, by your vote of 5 ayes, 2 nays, you've given Senate Bill 1418, as amended, a do pass recommendation.